This is Christian attorney R.L. Johnson, lawforlife.us. Today I will cover part 7 of my 4-part series on surviving financial challenges during the COVID-19 pandemic. In the first 3 parts, I talked about determining whether or not bankruptcy was in your interest in the first place. And I also mentioned that in my estimation, filing bankruptcy should be a last resort when lesser means have failed, or it was determined by you upon a proper analysis that it was not in your best interest to file bankruptcy. So in the prior sections, I provided tools and tips for viewers to look at to determine whether or not this was a step you needed to resolve your financial challenges. In prior sections, I also talked about some of the enhancements to the bankruptcy process that were brought on by the CARES Act, which was enacted in March of this year as a response from the White House to the COVID-19 pandemic. But today I will talk about eligibility for Chapter 7 bankruptcy, do's and don'ts. But the meat of this video will be dedicated to the means test, which is probably the most significant aspect of filing Chapter 7, because the means test helps you determine whether or not you're eligible to file. If you're not eligible to file, then you'll have to perhaps look at another avenue of relief provided by the code, say Chapter 13, which I covered in Part 3. Now, it's important to understand that in 2005, the Bankruptcy Abuse Prevention and Consumer Protection Act radically changed the bankruptcy code in such a way that it made it more difficult for people to receive discharges in Chapter 7 bankruptcy. The goal of the Abuse Prevention and Consumer Protection Act was to prevent people from abusing the Chapter 7 process and to encourage more people to file Chapter 13, which I covered in Part 3. It did that by imposing a means test on all individual filers. Now, there is one key exception for disabled veterans who were injured in service to the country or in a homeland security capacity who incurred debt during that period of service. But aside from that, individuals whose debts are primarily consumer in nature will have to complete and successfully satisfy the means test in order to be able to proceed under Chapter 7 of the Bankruptcy Code. One other key provision of the Abuse and Prevention Act was to exempt from the assets in your bankruptcy estate Roth IRAs and certain other retirement assets. So first I'll talk about eligibility under the code. The thing to know is that an individual can file Chapter 7. However, when an individual files Chapter 7, he or she must complete and receive a certificate in credit counseling from a bankruptcy court approved credit counseling agency. Now, when we visit the bankruptcy court website momentarily, you'll notice that there's a tab for links to other sites. And if you click on that tab, it will take you to a list of bankruptcy court approved credit counseling agencies. Also among those who can file Chapter 7 are corporations, partnerships, and other business entities. However, business entities do not have to take the means test. So let's jump right into the means test. And rather than get into a long discussion about how the means test actually works, I'd rather go right to the site and do a simulated means test online. The place to start is to go to uscourts.gov. That's the website. Once there, you'll see a location tab. In the location tab, you want to type in your state. Once your state appears in the search bar, you click on that and it will take you to your state. Now, for purposes of this illustration, I'm going to just pick Alabama because Alabama is the first state alphabetically in the union, and it'll simplify the process moving forward. Now, once you click on your state, you'll go to the federal court finder, scroll down to find the specific bankruptcy court. And of course, you want to find one that's closest to and that serves your home. If you look on the right side of the page, you'll see a drop-down list for districts in Alabama, and we're going to select the Alabama Middle Bankruptcy Court. From here, you click on OK, and it will take you to the Middle District of Alabama's page. Now, while here, you can see there are various tabs at the top of the page. Over to the far right, you'll see a Related Links tab. If you were to click on that, it would take you to a list of approved credit counseling agencies. But while here, let's click on Fees and see how much it costs to file a Chapter 7. As you can see, the petition fees are listed here on this page. Chapter 7 is the first of the chapters listed, and the fee for filing a Chapter 7 is $335. We'll note incidentally that the fee for filing a Chapter 13 is $310, and these fees do include the court's administrative costs. If you look over to the left of the screen, you'll see that there's also a list of approved credit counseling agencies on this tab as well. So if you wanted to find a credit counseling agency closest to your home, that particular link is also provided on this page, and you simply click on that and it would take you to a list of providers, and from from there you can determine which one is closest to you. Now, the means testing information or the means testing data is concerned with determining whether or not your income over the last 6 months is within the average income of individuals living in your state. And for purposes of the means test, the court relies on census data. In order to find out if your income is within that threshold, you need to go to justice.gov, a website maintained by the Department of Justice, where this information is stored and can be accessed for purposes of determining if you are within the threshold of individuals living in your state. So while on this page, you'll scroll down and you'll see a section entitled Data Required for Completing the 122A. That's the form that we're going to complete to help us determine whether or not we can file Chapter 7. And this information is also useful for completing Bankruptcy Form 122C, C as in Charlie. Beneath this title, you'll see a drop-down list that encompasses timeframes going back as far as 2005. And each of these timeframes captures data compiled by the Census Bureau for each state in the Republic for that time frame. Now, when you're looking to determine if you're going to be able to file Chapter 7, you want to pick the time frame that's most current, which is going to be the one at the top. And in this particular instance, it's May 1st, 2020. So you simply select that time frame, click go, and it will take you to another page. Now, on this page, you'll see means testing listed at the top of the page. And under that, you'll see that this is Census Bureau IRS data and administrative expense multipliers for cases filed on or after May 1st, 2020. Scroll down a little further and you'll see the title Median Family Income Based on State, Territory, and Family Size. Beneath that, you'll see there's an option for downloading an Excel spreadsheet, which is populated with all of the national data for this time frame. But we're going to click on the median family income based on state or territory and family size. And here again, you see that at the top of the page, we're looking at census data compiled for purposes of cases filed on or after May 1st, 2020. Again, for purposes of this illustration, we're going to simply randomly pick Alabama, and the example that I will use to complete the required means testing form will be based on 2 individuals who live in Alabama. So at the top of the page, you notice that you have your states listed, and the states are listed alphabetically. And then across the table, from left to right, we see the state median income for Alabama residents for the time period covered for 1 earner, 2 people, 3 people, and 4 people. Notice there's an asterisk next to the top of the column for household or family sizes comprised of 4 people. If you go down to the bottom of the table, the asterisk was meaning to point you to the addition that you need to make for every individual in the family in excess of 4. So for every person above 4 in your household, you would add $9,000 to the income you're permitted to make and still file Chapter 7. Notice also that every state in the Republic has a different average income per earner. So according to the Census Bureau, the most current data available for Alabama residents indicates that the average annual income for 1 earner was $48,544, and for 2 people, it's $56,918. In our example, there are 2 persons living in the home, so we're going to have to eventually populate the form with this number, 56,918. Now, the bankruptcy websites all contain 2 sets of forms. The first set are local forms, and the second set are official bankruptcy forms. The means test form, the 122A, is an official bankruptcy form. So we have to return to the website for the Middle District of Alabama, go to the Forms tab, and access the official bankruptcy forms. Now, once at the official bankruptcy forms page, there's another hyperlink to click on that will take us to a list of the forms. So we're going to do that. And once at the official bankruptcy forms page, you can see all of the forms that are available to filers for all of the chapters of the bankruptcy code. So not all of the forms listed here would be used in any particular kind of bankruptcy. They're all kind of mixed in, but the intent is to give each form a serial number and to list those forms alphabetically according to serial number on this page. So we're simply going to scroll down until we find the form that we need. And that is the B as in Bravo 122 A as in Alpha -1, which is entitled Chapter 7 Statement of Current Monthly Income. Over to the very right of that, you'll see the category of form that this is, and this is a means testing form, and this is the one we're going to select. Now, once on the form, you're simply going to populate all of the fields, and we're going to name our first debtor John Doe Mills, and our second debtor Sally Sue Mills. Notice to the right of the box where the debtors indicate their names, there's another box containing 3 check boxes. And you see the very first one there says there is no presumption of abuse. So remember that, because we're going to need to come back to this box when we're done completing the form. Now, for purposes of this example, Sally and John are married, living together, but John is filing bankruptcy, Sally is not. Now, beneath the parties' names, you'll find the words United States Bankruptcy Court for the blank, District of blank. This is actually a drop-down menu provided by the court and embedded in the form that lists all of the bankruptcy courts in the Republic. So if you click on that area, you'll find all of the bankruptcy courts will be populated there in a drop-down list, and our court will be the first one. You simply click on that. We don't have a case number yet, so we simply will skip that stage of the form, scroll down. Because in our example, John and Sally are married, but Sally is not filing bankruptcy with John, meaning whatever debt she might have, she's going to keep, while John is looking to liquidate all of his debts. We're going to click married and your spouse is not filing with you. We're also going to click living in the same household and not legally separated. For the sake of simplicity, we're going to assume that John makes $1,500 a month and that he and Sally work in the same place and make the exact same salary, and that they have not experienced any unemployment for the last 6 months or had any other income other than their salaries. Now, typically when you do a means test, the way it's done is you go back over the last 6 months prior to filing, and you compile all of your sources of income for that 6 months. Now, because of this, timing of your filing can be crucial. For example, if someone is a seasonal worker and they're out of work as a function of the nature of their job for, say, 4 or 5 months out of the year, then those 4 or 5 months that they're not working, but maybe 4 of the 6 months that you want to include when you're filing Chapter 7, just in case your annual income taken as a whole would push your income beyond the state median income for the number of earners in your family size. But for simplicity's sake, we're going to simply say that John and Sally have not experienced any unemployment, and that every month they make the exact same amount. There's been no overtime to speak of, so their paychecks have been identical for the last 6 months. Now notice when you get down to line 4, we have to include Sally's income because she is regularly contributing to the household. If John and Sally were married and she was not regularly contributing to the household, then we would not be required to include her income. For example, if she was a stay-home mom and didn't have any income at all. But in this case, they're both equal earners and they're both equally contributing. The only difference is John's requesting relief under Chapter 7 of the code and Sally is not. That said, we're going to go ahead and populate all of the other fields with 0. And now we're on page 2, which requires you to list other sources of potential income, including unemployment compensation, pension retirement income, or income from any source not otherwise already listed above. Note at line 10, the form instructs that if you receive payments as a result of the CARES Act, need not be listed here. So those payments, if you received any, or if you receive any moving forward from the second stimulus package, those payments that were appropriated by Congress and signed into law by the President back in March need not be listed on this form as income. Now down at line 11, we're going to calculate monthly income for the last 6 months for both John and Sally. And of course, because we have no other sources of income, unemployment or anything else, we're going to just add the 15 to the 15, which gives us $3,000 per month for the household. And then at line 12A, we're going to re-enter that number again. Then we're going to multiply that 3,000 by 12, which gives us $36,000, which is, pursuant to the means test, the income for John and Sally's 2-person household. Next, we go down to line 13. You populate this field with the state of residence, and below that with the number of persons in the household. And then at line 13, in the box provided, we're going to return to the census data form, which has already told us that the median income in the state of Alabama for the period covered for a 2-person household is $56,918, and we're going to insert that number into box 13. Next, we drop down to line 14, where we're told that if line 12B is less than or equal to line 13, which is the census data number, we are to return to the top of page 1 and check the box indicating there is no presumption of abuse. So we're going to check box 14A, and we're going to note that had it been the case that line 12B, meaning John and Sally's annual income, had turned out to be more than the amount of the median income for Alabama residents with a two-person household, the presumption of abuse would have arisen, and we would then have to go and complete not only the rest of this form, but Bankruptcy Form 122A as in alpha -2, which requires a showing of special circumstances necessary to overcome the presumption that we were trying to abuse the code, essentially. So we return back to the top of page 1 as instructed. We check box number 1, which says there is no presumption of abuse, which is frankly the best news we've had since we entered the process. Then we go down to page 3, part 3, and both John and Sally have to sign and date the form at part 3. Now, just for purposes of illustration, let's take a look at official form 122A-2, which is the form John and Sally would have had to complete had their income been in excess of the state median for Alabama residents with two-person households. Now, notice that part 1 of the form requires a determination of John and Sally's adjusted income. Part 2 requires them to calculate deductions from their income. And Part 3 requires a determination of whether there's a presumption of abuse. So there would have already been one presumption of abuse made in the hypothetical. But then as we approach the other form, which is the special circumstances test, at Part 3, there's yet another test after having completed parts 1 and 2 to determine if we have overcome the presumption of abuse of Chapter 7 of the Code. Part 4 requires specific details about the special circumstances. Now, many special circumstance cases involve serious health problems that a debtor may have experienced. There may have been a family emergency that caused the family to fall into arrears with creditors, or to otherwise have to overextend themselves in order to care for an ailing family member or to deal with a family emergency. Part 4 is where you would give specific details of those circumstances. And of course, Part 5 would be where you would sign and date. And again, if this was John and Sally's circumstance, they would both have to sign and date the form. Interestingly, the code does not define the terms household, family, or dependents. However, the Bankruptcy Court has developed some guidelines for purposes of determining for the means test the size of your family. And in essence, the Bankruptcy Court uses the census data to determine household size. The first thing that is looked at is whether or not the group of people have lived in that home for at least a year. Second is whether or not those individuals living in the home have pooled their incomes. And third is whether or not the persons living in the home acted as an economic unit. So in short, if John and Sally had 2 kids, for example, their household size would be considered 4 persons under this test. Now, there's some other things that the test presumes that may not have been demonstrated in the illustration I did because it was fairly simple. But the mathematics behind the test are that if a debtor's net income is over $12,850 or 25% of the debtor's non-priority unsecured debt, there's a presumption of abuse. And the whole idea of the presumption of abuse is that the mathematics behind the means test are supposed to flesh out whether a person could dispose of all of their consumer debts with relative ease. Now let's talk about individuals who are not permitted to file Chapter 7. The first on the list are individuals who have filed Chapter 7 in the last 180 days and had their petitions dismissed for willful refusal to comply with an order of the court. The second is when the debtor voluntarily dismissed their petition or had their petition dismissed after a creditor sought permission from the court to go after the debtor's assets that were secured by a lien. An example of that would be if you had a note on your car, meaning you still had payments due, and in the contract you signed when you purchased your vehicle, you indicated that in the event you did not make your payments on time, the holder of the note was permitted to repossess the vehicle. And then you turned around and went into bankruptcy court with that debt still unsatisfied. The creditor then asked the judge to set aside your request to dispose of that particular debt. And then you noticed that that was happening and you asked the court to dismiss your petition, which of course is your right. You are not going to be able to refile a bankruptcy under Chapter 7. So in other words, the code presumes that you are abusing the process by trying to avoid paying your secured creditors. So how does Chapter 7 work? Chapter 7 begins with the filing of a petition, and the petition has to be filed in a state where you have resided for at least 6 months prior to filing. So if you recently moved, you're not going to be able to file in the district where you recently moved. You have to have lived in that district for at least 6 months before you file. That's the rule for individuals. Businesses, on the other hand, can file where they're organized. And as many people know, you can organize your business in one state and operate in another. Many businesses are Nevada corporations and they operate in California, or they may operate throughout the United States. So a business can file where they're organized, they can file in their principal place of business, and they can also file where a lot of their assets are physically located. In addition to your petition, you have to file your schedules, which include your assets and liabilities, schedules that reflect your current income and expenditures, the statement of financial affairs, which is the most extensive document that you need to complete as part of the Chapter 7 packet. And in that particular form, which is probably 15 or 20 pages long, if properly completed, you will detail all of your financial affairs for over the last 2 years or more, including how much you paid your lawyer if you chose to hire one to assist you with your Chapter 7. You also have to list all of the executory contracts that you have that are in effect at the time that you file your Chapter 7. Executory contracts are things like leases or other contracts that affect your property or your assets that have not been completed at the time you file your petition. And the most common example of that would be a lease, an unexpired lease. Now, interestingly, another aspect of Chapter 7 that would preclude the completion of the means test would be if most of your debts were not primarily consumer debts. And consumer debts are debts that you incur for personal or household or family purposes. For example, if you went and borrowed money from a furniture store, or you financed furnishings that you bought from a furniture store, those are classically considered consumer debts. However, if you owned a small business and you were filing Chapter 7, both on account of your small business debts and your individual debts, if the majority of your debts arose from your business, even though you might have a substantial amount of consumer debts, you would file that as a non-consumer Chapter 7, because that Chapter 7 would then be characterized as one that was not composed of primarily consumer debts. I already mentioned the credit counseling certificate. The credit counseling certificate is usually good for 6 months, but of course, most people will complete credit counseling and file days thereafter. Now, if during the credit counseling process, you sit down with a credit counselor and you devise a payment plan to repay your creditors, you have to also submit that payment plan or repayment plan if it was completed within 60 days of the filing of your petition. And I'll just note parenthetically about the credit counseling. Again, you have to go to the Bankruptcy Court's website, and that is the Bankruptcy Court that serves the district in which you live. Find the approved list, find one that's closest to your home, but also know that many of the credit counseling agencies will allow you to do the credit counseling over the phone, over the internet, using your computer, possibly even now mobile devices. Or if you prefer, you can go into the office, sit down with a credit counselor, and complete the counseling in person. It's entirely up to you how you do it. But the moment you complete that credit counseling, the credit counseling agency will produce a certificate with a serial number on it. They will email that to you or your attorney, and then you can file that with the court at the same time you file your petition. In addition to all of the schedules, your petition, your credit counseling certificate, you also have to pay your bankruptcy filing fee. And you'll recall when we went to the bankruptcy site, the fee to file a bankruptcy is $335 for Chapter 7. You have to pay that fee also at the time you file your petition, or your petition will be denied. Now, many people who file Chapter 7 do not have $335, in which case you can complete a waiver form. And in order to receive a waiver of the bankruptcy filing fee, you have to demonstrate to the court that your annual income is less than 150% of the poverty level. Now, there is an installment option when you pay your bankruptcy fee where you can pay a portion of it up front and pay the other portion within 2 weeks of filing. But if it turns out you can't even afford to do that, then the bankruptcy court may grant you a waiver of the filing fee, in which case the filing of your Chapter 7 will be at no cost to you. Now, after you complete the means test, which is the most important place when you start your bankruptcy, because if you can't satisfy that test, numerous problems ensue in terms of trying to be able to satisfy or overcome the presumption of abuse of the code. The next most daunting aspect of a Chapter 7 is the numerous forms you have to complete, which require specificity, accuracy, and honesty. As a result, preparing to file a Chapter 7 can require a lot of homework and sometimes a very feverish search for documents to be able to provide accurate numbers necessary to complete all of these forms. So I usually advise people to start off by ordering their credit report from all three credit reporting agencies. These reports together should hopefully list every creditor that you have that has made a report to a credit reporting agency. But you also need to list things that you know are debts that are not listed on your credit report. For example, if you owe a relative money, you need to list that on your forms as well. You also need to list court judgments, if any, which sometimes do not appear on credit reporting forms. And as I'll mention towards the end when we talk about the court denying the discharge, failure to list creditors can be fatal to your discharge. So you want to make sure you list any person that you owe money or you think you may owe money on those forms. There's no harm in listing someone that you may not owe, but not listing someone that you owe can be fatal to your case. In addition to the persons you owe or the entities that you owe, you need to list the source, the amount, and the frequency of your income. And this includes income to which you may have a right to enjoy in the future, but that you may not have at this time. You'll have to list every piece of property you own. I mentioned this, I believe, in the first video, where if you have jewelry or any asset that you choose not to list on the schedules because you think maybe it's not important or it's not really worth anything, and you're discovered later, this can be fatal to your Chapter 7 as well, because everything you write on those schedules is offered to the court under penalty of perjury. And I can assure you the bankruptcy court takes it very seriously. And I can't tell you how many times people have either omitted things accidentally or because they didn't think it was worth mentioning. And this omission or these omissions were later discovered by the trustee. This is a position you do not want to be in when you're asking the court for relief. You'll also have to make a detailed list of all of your monthly living expenses, including food, clothing, shelter, utilities, every penny that you're spending. And that also includes expenditures for medical bills, medicine, or other healthcare expenses. This leads to the next really important aspect of your Chapter 7, and that is property that you are allowed to keep after the Chapter 7. This is known as exempt property. Now, exempt property is treated in one of three different ways. First, the Bankruptcy Code, specifically Section 522 of the Bankruptcy Code, enumerates specific pieces of property and the values of those pieces of property that you can exclude from the bankruptcy estate, meaning you can keep those pieces of property after the bankruptcy is over and no one can come after you and try to later take those pieces of property. Now, the Bankruptcy Code has a list of items, but some states have taken advantage of a provision in the Bankruptcy Code that allows the state to determine what property is exempt and to assign a value or a dollar amount to that exempt property. Then the third potential category would be states that allow you to choose between the federal list of exemptions or the state list of exemptions. And savvy attorneys and persons who understand the code, whether they be attorneys or not, are going to always opt for the list when it's available to you based on where you happen to live, that allows them to keep the absolute most amount of their property. But this area is also fraught with danger, because if you were to miscalculate or misread the statute or take a liberty that is not afforded to you by the statute, that miscalculation can cost you a piece of property that you may have otherwise been able to have exempted from your bankruptcy estate. But by way of illustration, Section 522 of the Bankruptcy Code allows you to exempt $15,000 in real estate or personal property, $2,400 in one motor vehicle, $400 in any particular item, or $8,000 in the aggregate in household furnishings, household goods, and wearing apparel. So most of your household furnishings and your clothing, your televisions, things like that, the computers are going to be covered by this particular $8,000 exemption. You're also allowed to exempt up to $1,000 in jewelry that's held primarily for your family or your personal use, $800 plus $7,500 of any unused portion of your $15,000 personal property exemption. That was the first one I mentioned. And this $7,500 is sometimes what we refer to as the wild card. So if, for example, you had $2,000 in jewelry, you can apply the $1,000 exemption specifically set aside for jewelry used for personal use or by members of your family, and add to that $1,000 of the $7,500 to cover the other portion of your jewelry, which is not covered specifically by the jewelry exemption. You can also exclude from the bankruptcy estate $1,500 in value for implements, professional books or tools used in your trade. You're also allowed to exempt from the bankruptcy estate any unmatured life insurance contract that you own, as well as $8,000 of any unmatured life insurance contract. Now, after all of your schedules are filed and approved by the bankruptcy court clerk, there's going to be a meeting of creditors. But I want to talk a little bit about filing with the bankruptcy court. For over a decade, all federal filings have been done electronically. This includes the bankruptcy court. Now, that doesn't mean you still don't have to have physical schedules, because you do. In fact, if you're called to a meeting of creditors, you will need to bring with you the actual forms printed out and signed. In fact, the original signature needs to be visible on your bankruptcy petition. However, almost everything that happens in a bankruptcy court is done electronically. So you simply download the forms from the bankruptcy site, complete the forms, sign the forms if necessary or if that's required, and then you upload the forms to the bankruptcy court's website. Now, in order to be a filer in bankruptcy court, you really need to have two different kinds of accounts. The first kind of account is called a PACER account, PACER. PACER is a website used by federal filers to access and view documents filed in any federal court in the Republic. Anyone can get a PACER account. You simply need to go to the website and sign up for it. Because of this, everything that's filed with the federal court is visible or discoverable by anybody with an internet connection who's willing to go ahead and get a PACER account. Now, these accounts are essentially free if you download documents up to probably 50 pages. After that, PACER will start assessing a fee for any document above the 50-page limit. But that being said, anyone can go on and view your bankruptcy schedules, and you can certainly view anyone else's bankruptcy schedules, as well as other documents filed with the federal court. So that's a PACER account. But in order to file a document with the federal court, you will have to have an actual eFiler account. The bankruptcy court will allow you to create an eFiler account, provided you follow all of the instructions and all of the rules associated with the e-filing process. This account is essential in order to be able to create a new account or to open a new case and to file into an existing case. And when you file documents using the federal court's e-filer system, the e-filing clerk will examine those documents. If those documents are deemed to be deficient, you will receive by email a deficiency notice. That deficiency notice will give you a specified period of time to correct or cure the deficiencies noted by the e-filing clerk. If you fail to do so, your petition, if it's been filed, could be dismissed. And as a matter of fact, if your petition is dismissed, the court may find that your failure to comply with the clerk's instructions to correct or cure a deficiency was willful. If the court makes that finding, you will not be able to refile for 180 days. Now, assuming all of your documents were filed properly and accepted by the clerk, between 21 and 40 days after your petition is filed with the court, the trustee of the court will hold a first meeting of creditors. Now, I've talked about the first meeting of creditors before. The first meeting of creditors occurs in something more like a conference room than a courtroom. As a matter of fact, you may never see a bankruptcy court judge unless a creditor institutes what's known as adversarial proceedings, during which they object to the discharge of a particular debt, or there's an allegation that you are attempting to abuse the bankruptcy code in some way. But you will most certainly see the trustee at the first meeting of creditors. At that meeting, you are to bring with you all of your schedules, including your petition, originally signed by you. If your spouse is a joint filer, he or she must also attend. When you enter the room where the meeting of creditors is being held, you'll find numerous other individuals who are there for the exact same purpose. And sometimes you'll see individuals seated there carrying briefcases and wearing suits. And those are probably attorneys representing creditors who intend to question debtors during that meeting. You also have to bring your Social Security card and your driver's license or state ID. The trustee will typically conduct these hearings alphabetically. When your name is called, you approach the table with all of your documents. You show the trustee your Social Security card and state identification. Thereafter, the trustee will administer an oath, and he or she will ask you if everything in your schedules and in your petition was true at the time you filed your petition, and if those schedules and those statements in your petition and schedules remains true today. That being done, there may be other questions asked of you. After the trustee is done with any questions he or she may have, attorneys for your creditors may also have questions for you. Now, as I indicated earlier, you have to provide prior to the meeting of creditors, and usually at the same time you file everything else with the court, all of your schedules and your petition, detailed information about your income and your assets. This includes income tax returns and pay stubs for the last 6 months. Sometimes the bankruptcy court refers to pay stubs as payment advices. But prior to the first meeting of creditors, the presumption is that all of your schedules and all of the documents required for the trustee to be able to effectively administer the bankruptcy estate have been provided. And that includes tax returns or transcripts from your tax returns, usually for the last 3 years, and including any tax returns to become due during the pendency of your petition. And as I mentioned, pay stubs for the last 6 months. Now, the bankruptcy trustee's role is to be impartial and to administer the liquidation of all of your non-exempt assets. During this series, I've talked about the distinction between secured debts and unsecured debts. Secured debts are debts in which the creditor was given a security interest in that property. And what that means is that along with your promise to repay, you promised that if you were to default on that loan, the creditor was then entitled to certain collateral that you pledged to guarantee that you would pay the loan back. Secure creditors enter into bankruptcy on a much higher level priority than non-secured creditors. Non-secured creditors are people like credit card companies in which they simply loaned you or extended you a line of credit, and then you went out and bought things using that line of credit. There's no collateral pledge guaranteeing that you'll pay them back. It's just simply your name on the dotted line. Secure creditors, on the other hand, have the right to place a lien on and, if necessary, seize property if they were to obtain a court order to do so, or in the case of a vehicle, they can repossess that vehicle or that item without breaching the peace. But the trustee's primary job, again, is to liquidate all of your non-exempt assets. So after you applied all of the exemptions that were mentioned, anything for which there is not a valid exemption can be sold for the benefit of your non-secured creditors. So then what happens is that bankruptcy cases become either asset cases or no asset cases. A no asset case is one in which either all of the property is exempt pursuant to one of the valid exemptions that we talked about, or the secured creditors have all been satisfied in accordance with their security agreements, and frankly, there's nothing left to sell. Those are no asset bankruptcies. Asset bankruptcies are bankruptcies in which people enter in with, let's say, 4 or 5 Rolex watches, and there's no exemption that will cover even one of those typically. In such case, those watches are going to be sold by the trustee for the benefit of creditors. Now, if it turns out that your bankruptcy is an asset bankruptcy, then unsecured creditors are required to file a claim with the court within 90 days of the first meeting of creditors. However, if one of your unsecured creditors happens to be a governmental unit, the governmental unit has 180 days to file a claim. The other thing that a trustee has are known as avoiding powers. Avoiding powers allow the trustee to claw back certain payments that you made prior to the filing of your bankruptcy petition. Those are sometimes referred to as preferential transfers. So, for example, if you owed your father-in-law a sum of money and you chose to pay your father-in-law back that sum of money prior to filing your Chapter 7, and it's later discovered that you did that, then that money that you paid to your father-in-law will be clawed back by the bankruptcy court trustee and reapplied to your debts held by unsecured creditors. Now the question then becomes, how would the trustee find out if in fact you did such a thing? Well, there's a very methodical and sometimes shrewd analysis of your finances. And I can assure you, the trustee and even some of the lawyers who might represent creditors who may object to either your discharge of their debt or to entries on your schedules on the theory that you're not disclosing everything that you have. But your bank accounts or your bank account records could be called or into question or subpoenaed. And if every penny you've earned in, let's say, the last 90 days prior to filing bankruptcy, or if there's a sum of money that's not accounted for, that's visible either in your tax returns or from a pay stub, let's say you received a bonus from work and that sum of money is not accounted for by an expenditure or a purchase, folks are going to start wondering what became of that money. And that's how people get caught in bankruptcy court, because sometimes they get too cute by half and they think they can either outsmart or outrun the process. And that, of course, is a fool's errand, because you're dealing with people who do this for a living. Thus, the problem becomes if you fail to disclose that transfer to, say, your father-in-law, and it's discovered by either the trustee or another interested party to your bankruptcy proceedings, this can be characterized as either perjury, meaning you did not disclose that when you were required to do so, or it could be interpreted as an attempt to defraud creditors. In either case, it could jeopardize your bankruptcy case, and your case could be dismissed, and you could be barred from refiling or you could face criminal prosecution as a result. So again, every aspect of your financial dealings needs to be fully disclosed, even if you think it may not be relevant, because someone may determine it is in fact relevant, if for no other reason because you chose not to disclose it. Now, assuming again all of your schedules were filed timely, accurately, you've complied with all of the requests and directives of both the court clerk, the bankruptcy trustee, and the judge, if such a request was made of you, you will be entitled to a discharge. And the good news is that 90% of the debtors who file Chapter 7 do experience a discharge of their debts and receive a fresh start. And that discharge usually happens within either 60 or 90 days of the first meeting of creditors. So if you emerge from the first meeting of creditors with no requirements being made of you, and if your case was filed properly, all of your schedules were clear and accurate, and there are no irregularities in anything you filed, chances are you'll get up from the table having met with the trustee with nothing left to do but your financial management course. Now, financial management is a course that you have to take after the first meeting of creditors, and it is slightly different from the initial credit counseling course that you took prior to filing. Now, I often tell people before they file Chapter 7 and sign up for the credit counseling course to inquire of the approved credit counseling agency whether or not they can pay for both courses at the same time. Oftentimes, if you pay for both at the same time, you'll get a discount because the credit counseling agency knows that you're going to need both in order to experience a discharge. So it's always wise to pay for them both at the same time, and you'll often get a reduced price. Those are the happy cases when people are able to actually walk out of the bankruptcy court with a fresh start and no debts to speak of other than debts they chose to keep. And which debts might a person choose to keep? Well, the biggest, of course, is the mortgage. Many people enter Chapter 7 thinking they're going to lose their house, and although some people do, many people do not because of what's known as a reaffirmation agreement. Now, you'll recall me talking about the automatic stay, and after you file Chapter 7, creditors are no longer able to deal with you directly or speak to you at all about any debt. In fact, they must cease all collection activity altogether, lest they be found guilty of violating the automatic stay, which sometimes can carry very hefty fines. But any debt that you had prior to the day you filed your petition, it's included in the bankruptcy estate, and if you receive a discharge of that debt, it's gone forever. Thus, if you have a mortgage going into a Chapter 7, that mortgage is going to either be discharged or it's going to be reaffirmed after you file your Chapter 7. Now, going into a Chapter 7 with a mortgage affords you two opportunities. One is you can have the debt discharged and you can walk away from the home free and clear, or you can choose to stay in the home, in which case you must reaffirm the debt. Now, reaffirmation is a process that requires you to complete an additional set of forms which bear on their face all kinds of disclosures about your rights and responsibilities and your understanding in going into a reaffirmation agreement with your creditors after your bankruptcy petition has been filed. Now, typically, these reaffirmation agreements will include, if not mirror, the terms that you already signed in your mortgage. It's just a different set of documents, but the interest rate will typically be the same. Sometimes it's even a point or two lower. The payments are usually what you were making. It may even be lower, but whether or not your interest rate remains the same or is lower is really a matter that's negotiated between you and your creditor, in this case, the mortgage company. But if you elect to reaffirm the debt you have, and it is not just limited to mortgages, it can be any debt in which there's a contract moving forward and collateral in your possession that you choose or would like to keep. That reaffirmation agreement has to be feasible based on the income you have remaining moving forward. And it also must be signed by you, the creditor, and the bankruptcy court judge. Many people, especially some of those folks who elected to represent themselves in bankruptcy court, miss this step, and it becomes a horrible nightmare when they emerge from bankruptcy court thinking somehow that their mortgage was discharged and yet they get to remain in their home. That is not at all how it works. There is no such thing as coming out of bankruptcy court with a free house. If you do not get that mortgage reaffirmed before your bankruptcy is discharged, you may find yourself in foreclosure proceedings shortly after your bankruptcy court discharge and wondering how this could have happened. Well, this is how it happens. You have to get, and it's your responsibility to get that reaffirmation agreement done before you actually emerge from bankruptcy court. And done means it's signed by everybody, including the judge. However, once a reaffirmation agreement is done and signed by the judge, it's entered into the court record, you simply need to make payments as agreed in that document. But that, of course, is your option. You do have the option of walking away from the home, essentially scot-free, and owing nothing, provided the judge allows you to discharge that debt. And that might be the biggest debt you have. And of course, the motivation for doing that is that if you don't do that, and there's a deficiency after the sale of your home, the lender may pursue other recourse in order to cure that deficiency. So getting that behind you and not having enough to worry moving forward is what a fresh start is all about. What grounds, if any, might a court have for denying you a discharge? Well, there are about 7. The first is when you fail to keep or produce books or financial records required or called for by the court or the trustee. You can also not receive a discharge if you fail to satisfactorily explain the loss of assets. You can fail to receive a discharge if you commit perjury. You can fail to receive a discharge if you fail to obey a lawful order of the bankruptcy court. You can fail to receive a discharge if you fraudulently transfer items. And how that manifests is someone decides that before they file bankruptcy, they're going to retitle their assets in someone else's name, or they're going to simply gift away assets prior to filing bankruptcy with the intention of recapturing those items after they emerge with the discharge. If that's discovered, that's considered a fraudulent transfer. And not only could you experience the dismissal of your petition, you could also experience criminal charges as a result of that. Along with that comes concealing or destroying property that would have otherwise become part of the bankruptcy estate. And finally, if you fail to complete an approved course in financial management, the court could elect to not grant you a discharge. And again, part of the motivation behind parts 1, 2, and 3 of this series was to really do a deep dive and determine whether or not chapter 7 or 13 was something that from which you would benefit in the first place. And the main reason why I think that's important is because some of the debts from which people are seeking relief are not dischargeable. For example, alimony and child support are not dischargeable. Many tax debts are not dischargeable. And monies borrowed for purposes of education from either the government or a nonprofit are not dischargeable unless there's an extreme hardship. What's an extreme hardship? An extreme hardship requires you to pass a 3-pronged test. The first prong in that test is that your current income and expenses are such that you could not repay the educational loan and maintain a minimal standard of living for yourself and your dependents. Prong number 2 requires a showing of additional circumstances that indicate that whatever hardship you're experiencing is going to continue for a significant period of time. And finally, the third prong requires that you have made a good faith effort to repay the loan. So if you haven't made any payments on your student loans, that alone is going to cause you to be impaled on the horns of this particular test. So I typically tell folks when they have student loans, you might want to plan to keep them because it's very hard to pass that 3-pronged test. The fourth category of debts that you cannot discharge are consumer debts made to a single creditor totaling more than $725 for luxury goods or services. Now, that's an important distinction to make because if you incurred debt in the excess of $725 for things that were necessary for yourself or your family, food and clothing, utilities, things like that, then that particular test does not apply. Fifth on the list is that if you had an open line of credit and you used that open line of credit and expended it to the tune of $1,000 or more within 70 days of having filed bankruptcy, that debt is not dischargeable. If you were involved in a malicious injury of someone else or their property and there are costs associated with that malicious injury, those costs are not dischargeable. If you were driving under the influence and someone was injured or property was damaged and there were costs assessed for that, those costs are not dischargeable. And of course, if you were involved in a criminal proceeding and restitution was imposed by the court, at the conclusion of that proceeding, that restitution is not dischargeable either. There's another category of debts that's not dischargeable, but for this category of debts, the creditor has to come forward and complain within 60 days of the first meeting of creditors. And there are 3 of these. The first one is if you obtained a loan of money by way of making a false statement to the creditor. The primary example of this is where someone embellishes their educational work experience in order to induce a creditor to loan them money. If those false statements or that embellishment is discovered later and it is determined by the court that it was that lie that induced the creditor to loan you the money, and that creditor comes forward timely, mainly within 60 days of the first meeting of creditors, that debt is not going to be discharged. And as a matter of fact, if the court was to find the deception egregious enough, your petition can be dismissed in its entirety. The second category is outright deceit or fraud, which might be slightly different but not entirely distinctive from, let's say, embellishing some facts. And the third is when you maliciously destroy property of an entity or a person. Now, the only thing that might dissuade or discourage a creditor from coming to the court and making the allegation that you embellished facts or that you lied or you somehow committed fraud to induce them to loan you money is the fact that the creditor has to show that their position is substantially justified. If they're not able to meet that test that's determined by the court, they're going to be stuck paying your attorney fees if you have an attorney. So that might be a powerful disincentive for someone to bring a case that is not ironclad, indicating that you somehow or another obtained a loan using false pretenses, fraud, or deceit. And finally, I mentioned this in the beginning, if you fail to list a creditor in your bankruptcy, subsequently receive a discharge, and that creditor later finds out that they were not listed and as a result did not have notice of your bankruptcy and could not therefore participate and perhaps argue that your debt to them should not be discharged, the court could then, upon a finding and a reopening of your bankruptcy case, find that that creditor's debt or your debt to that creditor is not discharged or not included in the bankruptcy estate, and therefore you still owe it. So that's why I indicated earlier that you have to list everyone to whom you owe money, even if you're not sure if you still owe it, because failure to do so could result in that person later coming back and crying, saying, I never was told, and therefore this person should not be able to escape what they owe me. But the Sixth Circuit has said that if it's a no asset bankruptcy, that's a Sixth Circuit federal court, has said that if it's a no asset bankruptcy, the fact that they were not listed is of no consequence, because had they been listed, they still would have gotten nothing. But that is not every federal court that has that position. So the safer position is to simply list everyone and everything to whom you owe money and seek to have that debt discharged along with everything else. Well, that concludes my series on surviving financial challenges during the COVID-19 era. I hope you enjoyed it, or at least found some aspects of this very helpful to you. If you did, please share it with other individuals who might also benefit from the information. I hope that few, if any, people have to actually access this information to overcome a challenge. That is to say, I hope that everyone remains safe and is able to overcome this pandemic without financial hardship. And I also ask if you have any questions regarding the information provided in this series, please submit those questions to me. I will do my best to answer those questions. And please subscribe to the channel. Thank you. God bless.